Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering federal judge obliterates black or female only federal disaster funding. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from CBS News, black farmers might not receive their own debt relief funding. What do you mean black farmers might not receive their own debt relief funding? Well, what's been going on with the federal government is they've been, since the Biden administration has come in, coming up with programs to pay off debts of people of certain races or genders. And not even to just pay them off at 100% level, but to pay them off at 120%. How is it debt relief if I pay your debt and it's 120%? That's outrageous. And of course, it's also outrageous to discriminate against people based on their skin color and gender and not allow everyone to participate in the same program equally. But it's not just debt relief is a big deal, but it's not just debt relief. It's also, hey, how much do you owe? $1 million, $2 million, $500,000? All right, we'll give it to you plus 20%. But are you the right skin color? Are you the right gender? What are your sexual preferences? Let's talk details. That's ridiculous. And this federal judge, Kacsmaryk, is stopping it. From justthenews.com, court issues injunction blocking USDA disaster relief based on race or gender. And here's the background on this judge and the complaints about him from when he first got appointed. From the Dallas Morning News, in the middle of Pride Month, Senate confirms Texas judge who defended bakery that turned away gay couple. That's what attorneys do. Everyone is entitled to a defense. I don't know the details of this bakery case. I assume it's probably pretty similar to the Colorado bakery case that the Supreme Court ruled you don't have to bake an original cake for something that goes against your First Amendment beliefs. It's not about selling somebody a cake off the shelf. You can buy as many cakes as you want off the shelf at that famous Colorado bakery that wound up in the Supreme Court over an LGBT-inspired lawsuit. It's about when you tell a baker, you need to design a cake creatively for me this way. I'm not buying one off the shelf. You've got to make one and use your artistic expression, which is protected by the First Amendment, to make a cake that serves what I want. Well, that's speech. Artistic creation is speech. First Amendment protected speech. And of course, if a bakery or an artist is sued over refusing to do forced speech that goes against their principles, they should be defended and they should win every time. In another case coming from the Hill, federal judge in Texas blocks Biden rule expanding gun background checks. That's Judge Kacsmaryk again. And in another one of his cases, America's worst judge declares war on drag. It's a shocking rejection of basic free speech principles. Maybe it is, maybe it's a community standards thing, but Kacsmaryk is not big into drag shows. From Reuters, Trump-appointed judge won't force Texas University to allow drag show. Is drag protected free speech? I don't know. It doesn't seem like it. It seems like there are community standards because you're affecting more than just one person. It's not one person one-on-one with someone else. It's one person making a public performance. But let's let the court settle that one. And this isn't even the first USDA case that the federal government has lost when they try to create race-based criteria and other minority-based criteria excluding people of certain races or certain genders or certain skin colors. From the Pacific Legal Foundation, race-based COVID-19 farm loan forgiveness denies equal treatment to farmers. They also got an injunction from a judge in Florida, and the federal government changed the criteria for the loans because of their lawsuit. From justthenews.com, court issues injunction blocking USDA disaster relief based on race or gender. The group claimed the Biden administration has taken roughly $25 billion in disaster and pandemic aid approved by Congress for farmers in 8 programs and devised a system to make awards based on race and gender, among other factors, which violates the Fifth Amendment. A federal court in Texas on Friday ordered the United States Department of Agriculture, the USDA, to stop discriminating against farmers on the basis of race or sex when awarding disaster relief. But we just received a nationwide injunction in the Strickland versus Vilsack case. which halts the racially discriminatory farmer relief payments made by the USDA, according to the Mountain State Legal Foundation's Twitter post. Quote, "The payments will no longer go out while the case proceeds. A proud moment for us and our partners." And the way the plaintiffs won their case the last time was exactly the same way, from a temporary injunction. The case was brought by that legal foundation and the Southeastern Legal Foundation, who also confirmed the news. Quote, "The court's nationwide injunction ordering the USDA to stop discriminating against farmers in the administration of disaster relief programs because of their race or sex represents a win for freedom and equality." The Southeastern Legal Foundation told Just the News in a statement, "USDA has tried this before with other programs. SLF has taken it to court and won. We won't stop fighting for the constitutional rights of American farmers until USDA earns their trust through fair and equal treatment." Keep it in mind, you may not be a farmer. You may not know a farmer. I'm not a farmer. I don't think I know any farmers. If you're a farmer, I got a lot of respect for you. That's hard work. But it's also about setting precedents and saying, no, you can't do this with federal funds. Or not winning and saying, all right, well, we tried to win and we didn't. You now can do this with federal funds. You can discriminate based on race or gender or sexual preference or whatever the federal government decides they want to do, even if it's not in a law from Congress. And even if it was in a law, that's still not right. It still violates the Constitution. But aside from that, when we win on these precedents, it's important. We have to win on these precedents. It's a given. If we don't, we lose the country. And we start losing constitutional rights. A group of white farmers asked the court in April to approve an emergency injunction that blocks the department from using race, gender, or other socially disadvantaged traits to determine who gets disaster and pandemic farm aid and how much, claiming that natural disasters do not discriminate and neither should the USDA. The group claimed the Biden administration has taken roughly $25 billion in disaster and pandemic aid approved by Congress for farmers in 8 programs and then devised a system to make awards based on race and gender, among other factors, violating the Fifth Amendment. Quote, "The Constitution promises equal treatment to all Americans regardless of their race or sex," the farmers said in a court filing. It also promises the separation of powers. USDA broke both promises through the disaster and pandemic relief programs challenged here. And your Fifth Amendment rights in America are your equal protection rights, which means you get treated the same way everyone else gets treated. No exceptions. The group alleged that the department was discriminatory by defining farmers who are Black, African American, American Indian, Alaskan Native, Hispanic, Asian American, Native Hawaiian, Pacific Islander, or a woman as socially disadvantaged, and then gave those people more money than people not considered, quote, underserved, for the very same thing. The USDA's discriminatory programs appear to be rooted in an executive order from Joe Biden. Scott Wynn, who won a similar case, won in Florida. And this went all the way back to 2022. A lifelong farmer, Scott Wynn's livelihood depends on the yields of Wynn Farms, the farm he's owned in Jennings, Florida, which rests near the Georgia border since 2006. For years, Scott has produced sweet potatoes and corn while also raising cattle. COVID-19, however, has wreaked havoc on Wynn Farms. A drop in beef prices has deeply impacted the farm's revenue. COVID-19's related worker shortages and out-of-state travel restrictions also left Scott without enough help or supplies to plant sweet potatoes. Running a farm is tough enough without a pandemic. Long workdays that start well before sunrise mean little rest for Scott in an industry with very low profit margins, especially for smaller operations like Wynn Farms. But Scott also has federal farm loans of $300,000. So what farm income he does earn goes towards loan repayment. A farm loan forgiveness provision was baked into Congress's COVID-19 legislation, the American Rescue Plan Act of 2021. But Scott was not eligible because he's white. It turns out the law only provides loan forgiveness up to 120% of U.S. Department of Agriculture's loan amounts for minority farmers and ranchers. That is, government is using racial classifications to decide who deserves relief from COVID-19's economic devastation. The news came as a shock to Scott's family and his wife in particular, who works in the local school system where posters promoting equal justice under the law are commonplace. The blanket exclusion of white farmers from debt relief purportedly aims to address past discriminations against minority farmers and ranchers by the USDA. These historical wrongs have been previously addressed through administrative and class action settlements. Now government is trying to combat racial discrimination by mandating more of it. Really? There have already been administrative and class action settlements? That means people were actually paid money by the federal government already for discrimination in the past? Well, I don't know if it was fair or not, but now is not the time to adjudicate that after a financial disaster that's clearly affecting people of every skin color. For the wins, it's a matter of equal treatment among all farmers, whether or not any loan forgiveness program is in place. Instead of a level playing field, they're forced to farm at a government-sanctioned competitive disadvantage based on something as immutable as race and skin color. Such racial classifications, however, violate the Constitution's equal protection guarantee. In fact, the Supreme Court has repeatedly said government cannot do this except in very narrow cases of past discrimination. Scott fought back in federal court, and in June 2021, he won the first nationwide preliminary injunction against the unlawful farm loan forgiveness provision. The injunction stopped the government from distributing funds while litigation continued. And that's exactly what just happened on this new case. Here's how it turned out. On September 12, 2022, Scott voluntarily dismissed his case after Congress repealed the race-based program and replaced it with a race-neutral debt relief policy as part of the Inflation Reduction Act of 2022. And from the Washington Examiner, agricultural programs should focus on opportunity, not equity. Congress enacted the $1.9 trillion American Rescue Plan Act, which Joe Biden signed into law. Proponents lauded the act as a way to promote opportunity for working people and to give them a fighting chance after the devastation wrought by the COVID-19 pandemic. Yet one provision, which provides $4 billion to farmers and ranchers solely on the basis of race, was defended on another ground, equity. The Rescue Plan Act directs the Department of Agriculture to pay up to 120% of the loan amount held by socially disadvantaged farmers and ranchers at the beginning of the year. Eligible loans include private loans guaranteed by the department as well as those that the department offers directly to farmers. So private loans guaranteed by the department or loans directly from the federal government. Any loan you have tied to your farm, if you're the right skin color, they wanted to give you 120% of the value of that loan. Simply paying it off was not good enough. Many of the original loans are geared towards beginning farmers and require a would-be borrower to show an inability to obtain sufficient credit elsewhere. The path of opportunity, one would think, should be open to all of these farmers, but the Act defines social disadvantage in a crude way. The term is not defined by any objective criteria such as a farmer's income, experience, or losses suffered as a result of the pandemic. Instead, it's based solely on one's membership in a racial group. Minority farmers are considered socially disadvantaged and are entitled to a payment, no matter what their circumstances. White farmers, such as Pacific Legal Foundation's clients Julie Owen, a single mother in Virginia, and James Dunlap, who works 2 jobs in 100-hour weeks to provide for his 1-year-old in Oregon, are categorically excluded, and so was the WINS. Why? Less than 2 weeks after the program was signed into law, Secretary of Agriculture Tom Vilsack explained his view that the law was necessary, quote, to address long-standing equity issues and to respond to cumulative impacts of systemic discrimination. 4 federal courts in Florida, Wisconsin, Texas, and Tennessee have considered these arguments and rejected them. Perhaps the most thoughtful of those came from Judge Marcia Morales Howard, who ruled in favor of PLF client Scott Wynn and issued the first nationwide injunction prohibiting the government from distributing loan assistance on the basis of race. Notably, the court's opinion acknowledged a fact uncontested by the parties, that the Department of Agriculture had a dark history of past discrimination against minority farmers. Yet it also noted significant remedial measures undertaken by Congress in the past decades to correct the department's sad history of racial discrimination. These measures include $2.4 billion in payments to farmers who were discriminated against and extending the statutory limitations period to ensure that individuals who were the victims of racial discrimination would have their day in court. As 4 courts have found, the government could not present evidence that these measures have failed to remedy past discrimination. Thus, the department was put to the task of showing that the past discrimination lingers in agriculture today. You would think they would have evidence for that, and that's why they would have done this already. It wouldn't just kind of like be a general vibe or an idea, or some people were pushing you to do it, so you said, okay, sure, we'll just say it's past discrimination. Where's the evidence for this? They don't have it. This it failed to do. To be sure, the department cited articles claiming that the vast majority of pandemic relief in agriculture went to white farmers, But as the court noted, the parties agreed the relief was distributed on race-neutral grounds, such as farm size and crops grown. Thus, a number of race-neutral options, such as the one that distributes relief to smaller farms, would help farmers who were shut out of previous rounds of funding. Such a program would disproportionately benefit minority farmers, but it would not do so by resorting to crude classifications to unthinking stereotypes that farmers are all socially disadvantaged merely because they belong to a minority group. Further, racial disparities do not say anything by themselves. In a free society where individuals are able to make their own choices, we'd presume that there would be disparities based on race, height, and a host of other factors. Racial balancing, by contrast, is rightly forbidden. That endeavor can require the government to tell a person otherwise entitled to a job, a seat at a school, or another opportunity that the path is closed merely because there are too many of the same race already there. To the extent that disparities reflect the downstream effects of past discrimination, the government should endeavor to remove barriers such as onerous licensing requirements to ensure that every individual, regardless of heritage, can avail herself of the opportunity to succeed. For those of us who believe everyone deserves equal treatment by the government, regardless of their racial identity, race-based loan forgiveness is a mistake. In attempting to make up for the department's past discrimination, the government has reinstituted one of America's worst and most illiberal traditions, treating citizens unequally on the basis of race. This is another win for equal justice under the law. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.